Good morning everybody. To start with today's content of understanding the concept of banker's relationship with the customer. Let's recollect every banker and a customer has two sort of relationship. One is a particularly a special kind of relationship. Another one is debtor-creditor relationship. In the previous class we had learned about the concept of a banker and a customer having a relationship of a debtor and a creditor. The relationship of a banker with a customer as a debtor and a creditor is a primary general relationship, and the same banker who has a relationship with a customer as a beneficiary and a trustee, as a principal and an agent, as a lessee and a lessor, as a bailee and bailer, as an indemnifier and indemnified, as a consultant, as a guarantor, as a mortgagee and a mortgager is that of a subsidiary general relationship. And further, when we were able to understand about the special relationship, we understood that a banker and a customer has got an obligation and rights against the customer. Either it's a banker towards a customer or customer towards the banker. Such a relationship which comes as an obligation and a right is what is called as special relationship. On the basis of this concept, we were very clear and able to understand the relationship exists between the banker and a customer when the banker has an obligation to honor his customers' check, the circumstances and the conditions which has to be fulfilled for the banker to honor the check of a customer. And we were also able to understand it is an obligation of the banker to maintain the secrecy of the customer's account. But in undue circumstances, he has to answer to the queries of the enquirer. But when he has to answer the queries of the inquirers, he must have certain precautions to be taken and he must answer to those enquiries. And as a banker, he must maintain the secrecy of the customer's account, and unless and until it is a customer who gives instructions to the banker, he need not reflect whatever the information he has with the customer. And once instructions is given, he can answer to the enquiries. But when he answers, he must be honest, not negligent, maintain confidentiality, the secrecy, and based on the facts and figures, he must answer in a general manner, keep himself safe when he answers to the statements and enquiries whoever wants to know about the customer. Thus, as a special relationship he has towards his customer with regard to his obligations. Similarly, banker has certain rights of general lien. That is, as a banker, he has certain rights towards his customers, and that right is banker's right of general lien. And we have very clearly understood a lien is a right of one person to retain the property in his possession belonging to the another until the debts due from the owner of the property is paid. And this lien, what he possesses, it can be for a specific property, for a specific loan, then we call it as a particular lien. And when it is not for a specific property, but it can be sued for various other properties for the amount that is due, is called as a general lien. So the conditions to be satisfied for the enjoyment of the general lien must be clearly understood by the banker. He just cannot exercise his general lien. He can only exercise this right of general lien as to the instructions given by his customer only when he possesses the property in his own name and it is being inconsistent with the agreement. In further, we had various other discussion made with regard to general lien. Now, in today's content, we will continue this special relationship between the banker and customer. The relationship is with, once again, towards the banker's right of set-off. What is this banker's right of set-off? Banker's right of set-off means combining of two or more accounts, one of which is in the debt another in the credit subject to certain conditions. That means a right of set off means combining of two or more accounts. You have an opportunity as a banker to combine two or more accounts. Take for example an overdraft, fixed deposit account, one of which is in debt, another one is in credit, and both are in the same branch or in a different branch subject to certain conditions. So banker, like other debtors, possesses the right of set off, which enables him to combine two accounts in the name of same customer and adjust the debit balance in account with the credit balance in another. For example, suppose he has taken an overdraft from his banker to an extent of 9,000 rupees. He has a credit balance of rupees 7,000 in his savings bank account. The bank can combine both of these accounts and claim the remainder amount of rupees 2,000 only. So thus, the right of set off can be exercised by the bank if there is no agreement contrary to this right, and afterwards a notice can be served to the customer initiating the customer about the banker's intention to exercise the right of set off. I think I'm very clear. Banker's right of set off means, what is set off? It means to say you're going to combine two or more account. So it is a right of the banker to adjust the amount due to him from a customer on one account against the amount due from him to the customer on another account held in the same capacity. The banker can exercise this right of set off without previous notice to the customer. That is, automatic set off under certain conditions and circumstances, and right of set off by giving a previous notice to the customer. Automatic right of set off. Automatic right of set off can be made on the death, insanity, insolvency of the customer, on the insolvency of the partner of a firm, on the winding of a company, on the receipt of a garnishee order, on the receipt of notice of assignment of the credit balance of the customer, on the receipt of an information of a second mortgage over the security which is charged to the bank. The automatic set off can be applicable in the following circumstances. That is, for example, if a customer is no more, he is dead, he has become insolvent, then it automatically has a right for a banker to adjust the amount due to him from a customer on one account against the amount due from him to the customer on the another account, because it has been held in the same capacity. He can exercise this right of set off only when, how can he exercise this right? Only when the debt must be mutual. What does that mean to say? That means to say it must be due between the same parties. That is very important. Secondly, the right of set off can be exercised only if the customer's account opened in the same way, in the same capacity or right. For example, you cannot set off the credit balance in account held by a person as an guardian. Keep in your mind, I am making you very clear to understand. The right of set off can be exercised only if the customer's account opened in the same name and capacity or right. For example, it cannot set off the credit balance in account held by a person as a guardian against debit balance in his personal account. Thus, the right of set off is exercised only when, I want to make you very clear, the first point is when it is mutual. The second point is only if the customer's account is opened in the same name and in the capacity or right. Thirdly, the right of set off can be exercised only if the mutual debts are determined and certain in amount. The right of set off can be exercised only in respect of debts which are due and recoverable on the date of set-off. The right of set-off can be exercised by the banker only in the absence of an agreement to the contrary. Thus, a banker has a right to set off or banker has a right to combine the accounts. I think I'm very clear. You can combine the accounts only in the same capacity. Now let's go further with the special relationship that exists between the banker and the customer when he exercises his right to charge compound interest. That is, a banker has a right to charge compound interest when a banker grants an advance to a customer. He becomes a creditor of the customer. The banker has an implied right to charge the interest on the customer by the virtue of banking custom. That is, by practice of a banking custom, he has a right to charge interest on the customer. The system of charging interest on the principal amount as well as, so you have taken a loan of 10,000 rupees and you have agreed to pay to the bank at a rate of 10%. When you go for 10% on 10,000 rupees, you have to pay 1,000 rupees as charges or some calculation as much, 10 by 100 into 10,000, where 2 zeros goes and it is around 1,000 rupees. You have to pay the interest on the principal amount. But along with the interest that you have charged on the principal amount, you have to pay as well as outstanding interest of the previous period, which is considered as charging of the compound interest. So interest of this plus the previous interest which you have not paid will be added together and being charged as compound interest. And this procedure is followed by every banker in practice. Banker has a right to charge this compound interest. So when a banker grants an advance to the customer, he becomes a creditor of the customer. So on the basis of it, he has the right to charge interest by virtue of banking custom. The next factor is the relationship further continues when banker has a right to charge the incidental charges. What is an incidental charges? Incidental charges may take form of service charges. For example, you have asked to go for a bank for your withdrawals, but you don't have time to go there, so you go to an ATM. Through ATM, you make your withdrawals, and this is not done free of cost. There are certain charges which has been levied by the bank for the ATM withdrawals. You do a bank overdraft facility. You take a OD. When you take an OD in a bank, the OD is being given to the customer by charging certain fees, nominal fees for it. And that nominal charges what you are going to pay for taking or for rendering service is what is called as incidental charges. So incidental charges are the charges which take the form of service charges, ledger folio charges, processing charges, appraisal charges, handling charges, standing instruction charges, panel charges, stop payment charges. As a banker, it has an implied right to charge incidental charges on the customers for meeting the cost involved in keeping their accounts. It is levied in case of unremunerated current accounts which has been overdrawn from the current account, cash credit accounts. They are not charged on remunerative accounts, fixed deposit accounts, saving bank accounts. Banker has got a right to levy the commitment charges. What is this commitment charges? It is a clause which has been included in an overdraft as well as in a cash credit arrangement. That is, a banker has a right to charge to the borrower's account commitment charge on unutilized portion of the overdraft or cash credit limit for better management of funds. What is the idea behind it is, suppose you have got an OD facility given by the banker for rupees 10 lakhs. But as to the day's requirement, you are in need of only 6 lakh rupees. But the remaining 4 lakh rupees which has been unutilized would be left with you, and such unutilized amount or the portion of amount of the overdraft or the cash credit limit which is left with you will be asked for a charge by the banker. So the banker who makes charges for the unutilized portion of the overdraft or cash credit limit is what is called as commitment charges. Why the bank levies commitment charges is, though you are not utilizing it, it is for you to utilize whenever it is in need for you in the future, and the bank has to bear that amount with itself without being used. For that purpose, bank has a right to levy the commitment charges. The commitment charges on the unutilized portion of the overdraft. If you put certain charges in this manner, you can have a better management of the funds. Banker right to charge interest and commission. Banker is entitled to interest on advances and reasonable commission for other services rendered by him. As I have already said, a banker is entitled to interest. That means whenever a banker gives a loan and advance to the customers, it will have its right as to charge interest on those loans and advances, and also has a right of reasonable commission. Reasonable commission is they charge commission charges for underwriting of shares and securities, for payment of bills, for making of OD facilities, for making of remittance facilities. Nothing is done free of cost by a bank. It will charge some reasonable amount of commission for all those services that has been rendered by the banker. This is an implied right for him and available for him to charge interest. Banker usually follow the practice of charging interest every 3 to 6 months once. So banker has a right to collect from the customer a reasonable commission for his services. Banker has a right not to produce a book of accounts under Bankers Books Evidence Act of 1891. As per this act, a banker cannot be compelled by a court. That means it cannot be forced by a court today to produce his original book of accounts or to appear as a witness to prove the matters recorded in his books in any suit to which he is not a party. The court can do this to permit any party to suit, to inspect, to take copies of any entry in the banker's books of accounts, or to require the bank to produce before the court a certified copy of the relevant entry in his books. So that means to say, banker's right not to produce books of account under Books Evidence Act of 1891. However, in a suit to which the banker is a party, the banker can be compelled by the court. Sometimes when there is a legal case and the banker is one of the parties, in such a situation, a banker can be compelled by the court to produce his original books of accounts and appear as a witness to prove the matters recorded therein. Thus, we are able to understand in the special relationship between the banker and the customer exists not only primary relationship, not only subsidiary relationship, but there is also a sort of special relationship. And this special relationship has come into existence because of the obligations that has been bound by the banker towards the customer, and also because of the rights of the banker towards the customer. And understanding the rights of the banker towards the customer are the banker's right to set off or banker's right to combine accounts, banker's right to charge compound interest, banker's right to charge incidental charges, banker's right to levy commitment charges, bankers' right to charge commission, bankers' right not to produce books of account under Books Evidence Act of 1891. I think they are very clear that a banker's special relationship depends upon the banker's obligations and right regarding the relationship of bank and the customer due to his obligations and due to his rights. To conclude today's content, the explanation on the concept of the relationship between the banker and customer has further to be regarded with the apportionment of payments and garnishee order, and this would be explained in the later part. To end today's content, we have to understand further, analyze further with the help of multiple choice questions which has been put forth in the next slide. So going through the multiple choice questions, answering it reasonably, you'll be able to understand how the special relationship has been in existence with the banker and the customer. So I would like to conclude this. Thank you.